Ma'am, don't move. Hands up now.
That wallet is not mine. I found it.
I didn't
on the
ask for a
sidewalk.
story. Step off the porch.
The ID reads Daniel Park. The cash hasn't
Step
been touched.
down
I left it
from
open.
the porch.
I am Adaeze Okonkwo, retired associate.
Turn around.
A 67-year-old woman sweeping her front steps on a Saturday morning finds a wallet on her sidewalk. She picks it up. She reads the identification inside. She places it open on her porch railing, with the owner's name facing the street, sits down in her porch chair, and waits. Because the right thing to do is to give it back, and giving it back requires being somewhere the owner can find you. A police officer arrives. He looks at the black woman on the porch. He looks at the wallet on the railing. He puts her in handcuffs. The Honorable Adaeze Okonkwo is 67 years old, retired Associate Justice of the State Court of Appeals, 31 years on the bench. The author of 4 published opinions that currently govern unlawful search and seizure law in every jurisdiction in this state, including specifically the controlling precedent establishing that possession of found property on one's own residential premises, displayed openly with the owner's identification visible, does not constitute probable cause for arrest in the absence of additional evidence of criminal intent. She did not just know the law that was violated on her doorstep. She wrote it. She wrote it in 47 pages of analysis precise enough that its violation requires either a complete ignorance of it or a complete indifference to it. Officer Brett Salter, 28 years old, 2 years on the force, demonstrates both. Officer Brett Salter arrives at the address at 9:08 a.m. with a dispatch call describing a stolen wallet and the image of what a person who has taken something looks like. He finds a black woman on a porch with a wallet on the railing beside her broom. He does not run the address. He does not examine the wallet. He does not speak to the people visible on the street. He does not attempt to verify a single element of the explanation Judge Okonkwo begins providing before he reaches the bottom of her steps. He makes his determination in the time it takes to walk from his patrol vehicle to the base of the porch. Everything that follows, the arrest, the false incident report, the 58 minutes of custody, the criminal charge, the civil verdict, the federal sentence, and the statewide protocol that will carry her name, follows from that determination and from the 20 seconds that would have been required to make a different one. Daniel Park, 26 years old, a graduate student in urban planning, loses his wallet 4 blocks from Elmwood Avenue at approximately 8:45 a.m. He reports it at 8:59 a.m. The word stolen is the dispatcher's, not his. He said he could not find his wallet. The dispatcher asked whether it may have been stolen. He said he did not know. The dispatcher logged it as a stolen wallet report. That single word, applied without evidence to a report containing nothing more than a description of loss, transforms a routine found property call into a theft investigation and sets in motion the chain of events that ends with a retired judge handcuffed on her own porch at 9:11 a.m. Park begins retracing his steps at 9:03 a.m. He arrives at 1847 Elmwood Avenue at 9:48 a.m. He sees his wallet on the porch railing from the front gate. He walks up the steps. He picks it up. Every item is present and in the order he left it. He knocks on the door. Judge Okonkwo has been in custody for 31 minutes. The proof of her innocence walked to her front door while she was at the precinct. It stood on her porch for 40 minutes waiting for her to come home. Type 31 minutes if you understand what it means that he was 4 blocks away and walking toward her the entire time she was in handcuffs. This story proves that in America, a black woman can find a wallet, carry it to her own porch, display the owner's identification in plain sight, and wait 20 minutes to return it, and still end up in handcuffs on the steps of the house she has owned for 29 years by an officer who decided, before climbing those steps, that he already understood what he was looking at. The credential did not protect her. The precedent she authored did not protect her. The open wallet on the railing did not protect her. What ultimately protected the record was a porch camera, a graduate student who retraced his steps, and a jury that understood what 22 seconds of deposition silence means. Adaeze Okonkwo was born in Enugu, Nigeria, the third of 5 children raised by a secondary school headmaster father and a midwife mother whose combined influence shaped in Adaeze from childhood the 2 values she would spend her career honoring: the rigorous pursuit of what is true and the compassionate management of what is human. Her father held his students to precise standards because he believed precision was a form of respect. Her mother arrived at deliveries in the middle of the night and came home with a specific quality of attention that Adaeze absorbed before she had language for it. The practice of looking at what is actually happening rather than what you came in expecting to find. She came to the United States at 19 on a full academic scholarship, completed her undergraduate degree in political philosophy with first-class honors, entered law school the following year, and graduated first in her class 3 years later. She clerked for a federal circuit court judge whose approach to legal reasoning she has described in interviews as the single greatest professional influence of her career. She spent 4 years at a civil rights litigation firm, developing the precision of argument that would define 31 years of judicial writing. She was appointed to the State Court of Appeals at 36 by a governor who told her at the ceremony that he had read every brief she had ever filed, and that the court needed exactly the combination of analytical rigor and human attentiveness she brought to every page. She was the youngest appointee in the court's 104-year history. She was the first black woman to serve on that bench. In 31 years, she wrote 412 majority opinions, 107 concurrences, and 89 dissents. The dissents, her former clerks will tell you, are where you go to understand what the law should be. The majority opinions are where you go to understand what it is. 11 of her majority opinions were adopted as controlling precedent by the state Supreme Court. 4 of them, the Okonkwo opinions, named as such in every first-year constitutional law course in the state, established the framework governing unlawful search and seizure, the right to refuse warrantless property entry, the standard for probable cause determination at the moment of arrest, and the specific evidentiary threshold required before a person found in possession of property on their own residential premises can be lawfully detained. That 4th opinion is State v. Hargrove, decided 14 years before the morning of September 21st. The case involved a man arrested in his own driveway for possessing a bicycle reported stolen 2 days earlier. A bicycle he had found leaning against a dumpster a block from his house and carried home intending to check the local lost and found listings. She wrote 47 pages because she believed the principle deserved that depth, because she believed the law needed to say with enough precision to be unambiguous that finding something and stealing something are not the same act and cannot be treated as the same act without corroding the civic contract that allows a person to pick up what someone else has dropped and try to return it. Its central holding, distilled to the sentence that appears in every law student's case outline in this state: possession of found property on one's own residential premises displayed openly with the owner's identification visible does not constitute probable cause for arrest in the absence of additional evidence of criminal intent. Binding precedent. Every jurisdiction in the state. Governing Brett Salter's conduct on the morning of September 21st, whether he has read it or not. He has not read it. He has not been trained on it. He has not been required to know it exists. That absence of training is one of the 3 institutional failures the civil jury's $8.7 million verdict is designed to correct. She retired at 67 when early-stage arthritis in her writing hand made the sustained drafting volume unsustainable. She did not retire from Elmwood Avenue, from her Saturday morning routine, from the neighbors she has known for 2 decades, or from the practice of attention her mother modeled in delivery rooms in Enugu half a century ago. On the morning of September 21st, she rises at 6:30 a.m., makes tea from the blend she has ordered from the same Ghanaian grocery for 11 years, reads the newspaper front to back, and goes out to sweep her front steps at 8:45 a.m. The elm trees on Elmwood Avenue are in the first weeks of their autumn turn, the leaves moving from green toward the amber that makes the street look, on mornings like this one, like something painted. She is on her 3rd pass of the broom across the bottom step when she sees the wallet on the sidewalk directly in front of her gate. She picks it up. She reads the name, Daniel Park, State University student identification. She notes the cash without counting it. She will estimate $60. The inventory will confirm $63. She does not remove anything. She places the wallet on her railing, open, the identification card visible. She leans her broom against the railing. She goes inside for 30 seconds to retrieve her tea. She comes back out. She sits in her porch chair. She is going to wait. Someone always comes back for what they have lost if you give them somewhere to come back to. She has been sitting there for 20 minutes when Officer Brett Salter pulls up. Brett Salter has been with the City Police Department for 2 years. He completed a criminal justice degree at a community college, worked security at a shopping center for 8 months, and joined the force at 26. He is not notable in the ways that generate attention in either direction. He is punctual. He files his paperwork. He follows dispatch calls to their addresses with the efficiency his supervisors have noted in 2 annual reviews as his most consistent quality. The prior complaint against him is in his personnel file. A black woman named Gloria Webb alleged that Salter entered her backyard without a warrant after a neighbor's noise complaint. The reviewing sergeant noted reasonable judgment in an active call situation. Dismissed. No training ordered. No pattern review initiated. The complaint sits in the file the way complaints sit when they are resolved without consequence, as a record of something that happened and was decided not to matter, available to no one unless someone thinks to look for it, mattering to no one until it becomes the second data point in a pattern that only becomes visible when it is too late to interrupt. At 9:02 a.m., Salter receives the dispatch call. Stolen wallet, vicinity of Elmwood Avenue. He drives to the block, looking for a person who fits the image of a person who has taken something. He does not examine the contents of that image or where it came from, or whose face it is most likely to produce when applied to a residential street at 9 in the morning on a Saturday. He turns onto Elmwood at 9:08 a.m. He sees a black woman in a housecoat with a broom against the railing and a wallet beside the broom. He pulls over. He does not run the address, which would have returned Judge Okonkwo's name and 29 years of residence in 30 seconds. He does not approach the railing to examine the wallet, which is open with the owner's identification card facing the street. The arrangement of a person who wants the item to be findable, not hidden. He does not consider why a person who had stolen a wallet would be sitting on her front porch in plain view of a public street, displaying it beside her broom at 9 in the morning. He does not consider any of those things because the scene has already been resolved in his processing before he reaches the bottom of the porch steps. He sees a black woman. He sees a wallet. He has everything he needs. The incident report filed at 11:14 a.m. states that the suspect was found in possession of the reported stolen property and was unable to provide a satisfactory explanation for her possession of it. The first characterization is technically accurate in its narrowest reading and misleading in every contextual one. The second is false. Judge Okonkwo provided an immediate, specific, detailed, and entirely accurate explanation from the moment Salter reached the bottom of her steps. She told him where she found the wallet, when she found it, what she observed inside it, why she placed it on the railing, and how long she had been waiting. She told him her name and her title, and her 29 years at the address where she was being arrested. Every element of that explanation was confirmed accurate within 40 minutes by the wallet's owner standing on her own porch. The word satisfactory in that incident report will become, 14 months later in a federal deposition room, the word around which the criminal case turns. Attorney Renee Caldwell will ask Salter to define it. He will not be able to. She will ask whether an explanation confirmed accurate in every particular within 40 minutes of the arrest was, in his assessment, satisfactory. He will say he did not have that confirmation at the time. She will say, "I know." She will ask what information was available at the time that he did not use. He will name it: the address database, the wallet examination, the witnesses visible on the street. She will ask why he used none of it. He will say the situation required him to act on what was in front of him. She will place State v. Hargrove on the table. She will read the holding. She will ask whether, having now read the controlling precedent on this exact question, he believes the arrest was supported by probable cause. 22 seconds of silence. He will not answer. The jury will answer for him. The handcuffs go on at 9:11 a.m. on the front porch of the house Judge Okonkwo has owned for 29 years. The wallet remains on the railing exactly as she placed it. Open. Daniel Park's identification card facing the street. $63 untouched. Her broom leaning beside it where she left it when she went inside for her tea. She does not resist. She knows the porch camera is running and that its record will be more useful than anything she can say or do in this moment. She looks into it and says everything is being recorded. Salter says it will show her cooperating. She says it will show considerably more than that. Both are correct. She has walked down her own front steps in handcuffs at 9:13 a.m., while Reverend Ose watches from across the street with his Saturday morning coffee going cold. He calls Theodore at 9:14 a.m. Theodore is in his car at 9:16. Judge Okonkwo is in the patrol vehicle at 9:15, asking Salter whether he intends to leave the wallet unattended on her railing. He leaves it. He drives to the precinct. Daniel Park knows the wallet was in his back pocket when he passed Elmwood and 6th because he remembers its weight against the bus bench when he sat down at 8:44 a.m. He reports it at 8:59 and begins retracing his steps at 9:03. He reaches 1847 Elmwood Avenue at 9:48. He sees his wallet on the railing from the front gate. Open. His identification card visible from 12 feet. He walks up the steps. He picks it up. Every item is there, in the order he left it, as though it had simply been waiting for him. He knocks on the door. Sergeant Patricia Nwosu, who drove to the address when Theodore Okonkwo called the precinct, opens the door. Daniel Park tells her the woman who lives here found his wallet, that he lost it nearby and came back looking for it, and that everything is still inside. Sergeant Nwosu looks at the wallet in his hand. She calls the precinct. Judge Okonkwo is released from processing at 10:09 a.m. She has been in custody for 58 minutes. She is returned to Elmwood Avenue at 10:27, riding in the front seat of a patrol vehicle in the housecoat she put on to sweep her steps, to the house she has owned for 29 years, where Daniel Park is still on her porch because she asked him to wait and because he has spent 40 minutes coming to understand, with increasing and uncomfortable clarity, what his call to dispatch may have set in motion. She comes up her own front steps for the second time that morning. He starts to apologize. She holds up one hand. She tells him it is not his fault. She asks whether he would like a glass of water. He says yes. They sit on her porch while the elm trees continue their slow turn on Elmwood Avenue. There is not much to say between a person who found something and waited and a person who came back to find it. Theodore arrives at 10:31 a.m., sits in his car for a long moment, looking at his mother in her housecoat with a 26-year-old on her porch steps and her broom against the railing in its usual place. Then he gets out. Then he calls Renee Caldwell. Judge Okonkwo does not speak to the press. She does not post on social media. She does not call her former colleagues on the bench, though several of them call her when the lawsuit is filed, and news reports attach her name and title to the story. She is not interested in the public dimensions of what happened to her. She is interested in the completeness of the record and the precision of the remedy. Those are the things she has always been interested in. Nothing about September 21st changes that. She provides attorney Renee Caldwell with 4 items at their first meeting 11 days after the arrest. The porch security camera footage, continuous, high-definition, time-stamped from 8:52 a.m. through 9:15 a.m., capturing everything from the placement of the wallet through Salter's arrival and departure, and including, in the frames after his vehicle leaves, the wallet remaining on the railing exactly as placed. Her own handwritten account of the morning, written at her kitchen table on the afternoon of September 21st, while every detail was still precise. 7 pages, time-stamped, signed, drafted with the same discipline she brought to 31 years of opinion writing. Daniel Park's 911 call record and dispatch log, obtained through a public records request she filed the same afternoon. The call at 8:59 a.m. The dispatcher's word, the gap between what Park said and what was logged. And a copy of State v. Hargrove, placed on top of the stack and slid across the table without comment. Caldwell reads the relevant passage. She looks up. She says, "You wrote this." Judge Okonkwo says, "I wrote this." There is a pause in which both women sit with the specific quality of irony that has no adequate response. Then Caldwell says, "He arrested you in violation of your own precedent." Judge Okonkwo says, "He arrested me in violation of the law. The fact that I wrote the relevant portion of the law is, I suppose, an additional detail." She tells Caldwell she wants 3 things. The incident report corrected in the permanent official record, not administratively closed, but formally corrected, so that the characterization unable to provide a satisfactory explanation does not stand as the documented account of what happened on her porch. The prior complaint against Salter reopened and investigated with the rigor the original review did not apply, because Gloria Webb deserved that rigor 2 years ago, and its absence is part of why Judge Okonkwo is sitting in this office today. And a found property protocol training program, funded by whatever institutional damages are awarded, for every active officer and incoming cadet in the state, because the failure on September 21st was not only the result of one officer's assumption. It was the result of a dispatch system that logged a loss as a theft, and an officer who had never been required to know the law he was enforcing, and a department that had dismissed 2 complaints against him without examining what they represented. Caldwell files the lawsuit 6 weeks after the arrest. $8.7 million. Daniel Park contacts Caldwell 3 days after the filing. He has read the news report. He has read Judge Okonkwo's name and her title and the description of what happened on her porch. He has thought about the 40 minutes he spent on that porch. He has thought about the glass of water she brought him. He has thought about the fact that she told him it was not his fault with the same directness she brought to every other moment of that morning, as though the accurate assignment of responsibility were simply a matter of clear accounting rather than something she was managing on his behalf. He is not entirely sure she was right. He has been thinking about that too. He tells Caldwell he wants to provide a statement and that he will testify if it would help. He tells her he wants to be specific about what he found when he arrived at 1847 Elmwood Avenue. The wallet sitting open with his identification visible from the front gate. Every item of its contents in the order he left it. Positioned on the railing as though someone had thought carefully about where to put it, so that the person who lost it would find it immediately when they came back. He says, "That is exactly what it looked like. Someone had thought about what I would need when I got there and arranged the porch accordingly." I want to say that in a courtroom. I want to say it clearly, and I want people to understand what it means. Caldwell asks whether he would be willing to say it anywhere the case required. He says yes, without qualification. He testifies on day 3 of the civil trial. He is on the stand for 40 minutes. He is not a legal expert. He is not a forensic specialist. He is a 26-year-old graduate student describing what a porch looked like at 9:48 a.m. on a Saturday morning in September. And the jury finds him, by the subsequent assessment of every legal analyst who reviews the trial transcript, the most credible witness in the entire proceeding. His 40 minutes on the stand are the 40 most consequential minutes of the trial. The porch camera footage becomes Exhibit A. Continuous, time-stamped, high definition from 8:52 a.m. through 9:15 a.m. It shows Judge Okonkwo placing the wallet at 8:52. 16 uninterrupted minutes of a woman sitting in her porch chair. 3 pedestrians passing without incident. Salter's arrival, the full exchange, the handcuffing, and the departure. It does not show combativeness. It does not show concealment. It does not show what the incident report says it shows. Daniel Park's dispatch record becomes Exhibit B. His call at 8:59 a.m. using the dispatcher's word stolen rather than his own description of a missing wallet. The gap between what he said and what was logged is the systemic negligence argument in its most concentrated form. One word, applied without evidence, that transformed a lost property inquiry into a theft investigation and set everything in motion. The incident report becomes Exhibit C and the center of the criminal prosecution. Its false characterization, unable to provide a satisfactory explanation, placed beside the porch camera footage showing an immediate and accurate explanation, the officer made no attempt to verify. The jury needs to see the footage and the report shown simultaneously exactly once. Daniel Park's testimony becomes Exhibit D. His description of the wallet on arrival, open, identification visible from the gate, contents intact and in order, is the most direct human refutation of the stolen property characterization in the record. The person the wallet belonged to, describing what the person who found it did with it while she sat on her porch and waited for him to return. State v. Hargrove becomes Exhibit E. Caldwell reads the holding to the jury once. She reads the author's name. She looks at the jury for 3 seconds. She moves on. The jury does not move on. It is the first thing 3 of them raise when deliberations begin. Caldwell conducts Salter's deposition 14 months after the arrest, over 4 hours. She asks what observation led him to treat Judge Okonkwo as a subject. He says she was in possession of the reported stolen wallet. She asks whether he examined the wallet before approaching. He says he observed it on the railing. She asks whether he observed it was open with the owner's identification facing the street. He says he observed a wallet on the railing. She places the camera still image before him and asks whether that orientation is more consistent with concealment or display. He does not answer. She asks what explanation Judge Okonkwo provided. He recounts it accurately. She asks whether he attempted to verify any element of it before making the arrest. He says he could not verify it at the scene. She asks what verification was available that he did not attempt. He identifies 3: running the address, examining the wallet, speaking to witnesses. She asks why he used none of them. He says the situation required him to secure the scene. She places State v. Hargrove on the table. She reads the holding. She asks whether, having now read the controlling precedent, he believes the arrest was supported by probable cause. 22 seconds. He does not answer. Caldwell closes her folder. The civil jury deliberates for 1 day and 8 hours. $8.7 million. $3.2 million to Judge Okonkwo for civil rights violations, wrongful arrest, racial profiling, and punitive damages against Salter personally. $2.5 million funding the statewide found property protocol. $3 million for the systemic dispatch logging failure. Salter is terminated. Gloria Webb's prior complaint is reopened, found meritorious, and compensated. The criminal trial concludes 6 weeks later. Guilty. 2 years in federal prison. The found property protocol is adopted by every agency in the state within 1 year. 19 states requested at the following year's National Training Conference. It is named, in the state curriculum's official documentation, the Okonkwo Protocol. A journalist calls to tell her. She is quiet for a moment. Then she says, "I would have preferred it be named for someone who did not have to be arrested on her own doorstep to get it written. I hope it prevents the next one." Daniel Park graduates with his master's degree in urban planning 14 months after September 21st. His thesis examines how public space is policed differently in black neighborhoods than in comparable white ones, and what that difference costs in measurable human terms. He dedicates it to Judge Okonkwo with a note that reads, "Who showed me on a Saturday morning in September what it looks like when the problem gets built into the street before anyone has thought to question the foundation." She writes back on the cream notepaper she has used since her clerkship. She says the dedication is kind and the commitment is better. She says, "The most consequential decisions about how people experience public space are made at the level of the foundation, by people who have not asked whose experience they are designing for. Pay attention to the foundations. The rest follows from there." He frames the letter. It is the first thing he hangs in his office when he begins his first position at a city planning department. It is still there 7 years later when a journalist writing about the Okonkwo Protocol's 5th anniversary asks him what first brought him to the work. Reverend Adaeze is asked after the verdict whether he spoke with Judge Okonkwo about what happened. He says they sat together on her porch the following morning for about 40 minutes. She did not talk about the arrest. She talked about the elm trees, a book on colonial land law, and a former clerk who had just been appointed to a district court. He says she was not pretending it had not happened. She was insisting that it had not ended her. Those are different things. I have thought about that distinction quite a lot in the time since. He still has his coffee on his porch on Saturday mornings. She still sweeps her steps. They still wave to each other over the tops of the elm trees. $8.7 million, 2 years in federal prison, a statewide protocol in 19 states, a dispatch word reformed, a prior complaint compensated, a thesis dedicated to a retired judge who brought someone a glass of water on her own porch after being returned to it in a patrol vehicle. And none of it gives back the 58 minutes. None of it restores the quality of that Saturday morning before the patrol vehicle pulled up. None of it reaches the determination made in the time it takes to walk from a vehicle to the bottom of a porch. The determination that 30 seconds of address verification and 30 years of established precedent would have immediately and completely contradicted. The Okonkwo Protocol creates a mandatory verification sequence where before there was none. The address check is required. The examination of the property's condition is required. The witness canvass is required. The dispatch reform means lost and stolen are no longer interchangeable words in a call log. These requirements create procedural interruptions between arrival and assumption. They make the next September 21st harder to produce in exactly the same way. But the assumption itself is not in the protocol. It is addressed imperfectly and incrementally by consequences that make its cost visible enough that the space between observation and action becomes wide enough for a question to fit inside it. The 22-second silence in the deposition transcript is the most visible thing in the entire case. Not because it is dramatic, but because it is honest. It is the shape of an assumption that had already answered every question before it arrived at the scene. It is what the protocol was written to interrupt, and what the verdict was designed to make expensive. Judge Okonkwo still sweeps her steps on Saturday mornings. She still sits in her porch chair with her tea. The elm trees still turn every September. She occupies her porch fully, with the same quality of attention her mother brought to delivery rooms in Enugu 50 years ago. Look at what is actually there rather than what you expected to find. It is the testimony of someone who is not ended by what was done to her and who has chosen to make that fact visible every Saturday morning on Elmwood Avenue. The Honorable Adaeze Okonkwo spent 31 years writing the opinions that govern how this state's officers may and may not treat the people they encounter. She wrote the probable cause standard for found property arrests. She wrote the rules that were broken on her own doorstep by an officer who had never been required to read them. On September 21st, she found a wallet on her sidewalk, placed it open on her railing with the owner's name facing the street, and waited 20 minutes to return it. She was in handcuffs 9 minutes after the officer arrived. In custody for 58 minutes. The wallet's owner confirmed her account from her own porch 40 minutes after the arrest, with every item intact, exactly as she described. Salter was terminated, convicted, and sentenced to 2 years. The Okonkwo Protocol is in 19 states. Daniel Park's letter is still on his office wall. Reverend Adaeze still waves from across the street. She still sweeps her steps. So here is my question. If 31 years of judicial service, a published opinion establishing the exact probable cause standard violated on your own doorstep, a wallet sitting open on your railing with the owner's name facing the street, and the proof of your innocence walking toward you from 4 blocks away for the entire duration of your detention are not enough to prevent a black woman from being handcuffed on her own front steps, what is? Should officers who make arrests in violation of controlling precedent they have never been trained on face personal civil liability for that ignorance, given that the precedent is public, binding, and accessible in 30 seconds? And should the dispatcher who converted a lost property report into a stolen property call, the single word that started everything, face departmental accountability for the harm that one word produced? Share your thoughts in the comments. This story proves that writing the law does not protect you from the law being broken against you. That 31 years on the bench does not protect you. That an open wallet with someone else's name on the railing does not protect you. But a porch camera, a graduate student who retraced his steps, and a jury that sits with 22 seconds of silence and decides what it means, those things protect the record. And the record built the protocol. And the protocol makes the next porch different from this one. Adaeze Okonkwo waited 20 minutes for Daniel Park to come back. He came back. She was already gone. The Okonkwo protocol makes sure the next officer waits long enough to find out what he is actually looking at before he decides he already knows. Thank you for watching. I will see you in the next story.